All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
You may be seated. Good morning. Welcome to the First District Court of Appeal. Before we get started, I'd like to recognize some special guests that we have with us today. We have Professor Shirley Taylor's LLM students from FSU College of Law. Welcome. We're glad you can be with us today. Now we will turn to the one case that we have on our docket. It's the Florida Department of Children and Families versus Kevin Askew. The case number is 21-2499. Counsel for the appellant, you may proceed when you're ready.
Good morning, Your Honors, and may it please the Court. David Costello for the Department of Children and Families. I'd like to reserve 4 minutes for rebuttal.
So noted.
There are 2 legal principles at the heart of this case. The first is that an employer must take an adverse action against an employee before the employee can bring a discrimination suit. The second is that resignation typically does not count as that adverse action because the resignation is attributed to the employee. The employer has taken no adverse action at all. There's a narrow exception to that rule, and that's when the employer withholds the adverse action, so doesn't fire the employee, and instead forces the resignation of the employee by making the condition so oppressive or coercive that the employee has no meaningful choice. He just must resign. That's called a constructive discharge. That's the theory Mr. Askew proceeded under below, and that's the issue I'd like to focus my presentation on today, unless this court would rather me start elsewhere.
Well, I do have a question in that regard, and I guess it focuses on the misrepresentation element that could amount to a constructive discharge. And it's my understanding of the record that the pertinent misrepresentation that was alleged to have occurred was that the IG had completed the investigation, which it actually had not. The IG had found against Askew, which at that point we did not know that information, and that Askew would be terminated immediately or at the close of business that day if he did not submit his resignation, which I guess from that an inference could be had that there was no appeal process. So if you could address that alleged misrepresentation.
Of course, Judge Ray. So I think that the core of bringing in misrepresentation claims that you have to establish 2 things. You have to show that the facts were material, that were misrepresented, and then you have to show that you reasonably relied on those facts. And even spotting Mr. Askew right now for purposes of this argument that the facts are material, it was just not reasonable for him to rely on those statements, and here's why. Mr. Askew is entitled to substantial pre-dismissal process as a state employee, excuse me, and it was simply unreasonable for him to think that he could be fired at the end of the day before he had any of that process. Under Florida Statute 110.227, Mr. Askew is entitled to 10 days pre-termination written notice and a pre-dismissal hearing at which he gets to present evidence and convince his supervisors not to take the action.
But isn't it also reasonable for an employee to rely on what their supervisor is telling them? Arguably in the heat of the moment. Again, I'm relying on some inferences that could be taken from the evidence as to whether there could be a jury question.
Of course, Your Honor. I'd say 2 responses to that. First, certainly there will be cases when it's reasonable for an employee to just rely on what their supervisor has said, but I don't think this is one of those cases for 2 main reasons. The first is that Mr. Askew was trained as a supervisor and worked for 4 years as a supervisor for the Department of Children and Families. And as a supervisor, he was trained in pre-dismissal procedures, so it is unreasonable for him to believe that his supervisor could take these actions when he, as a supervisor himself, knew that he couldn't.
But laws can change, right? So I don't know what the timetable is here. But I guess going back to the extent that a supervisor is communicating things on from an IG's office, from a secretary or general counsel of a department's office that are staffed with lawyers, it would seem like you would presume that, well, if this is coming through those places, that they would know what the current state of the law is.
Well, I don't think that's right, Your Honor, and I think that the Fourth Circuit's decision in Stone really helps us here, and this is a decision that's cited in our initial brief and is also cited in Hargray. And in that decision, the Fourth Circuit considered a constructive discharge claim. You had a hospital who fired or said that they were going to fire a doctor at the end of the day, when in fact the hospital couldn't do that because the hospital bylaws had said you have a bunch of dismissal process, so you can't be fired immediately. And the doctor there resigned rather than accept the termination, and then he brought a constructive discharge claim like Mr. Askew has brought here. And the Fourth Circuit rejected that claim because it concluded that it's simply incredible for you to believe that you could be fired at the end of the day despite this process. The Fourth Circuit didn't look to whether, when was the last time the employee had looked at these rules. Instead, the Fourth Circuit assumed that you are expected to know rules that are designed to protect you, and that's what the Middle District of Florida did in Venero as well. And so there, because the doctor was an employee for 30 years, because he was a supervisor, because he had been around this process for a while, it was simply incredible for him to believe that he could just be fired at the end of the day like that. And so we think that this case is very much like Stone, and this court could rely on it to reverse the lower court's decision. But we also think that it was particularly unreasonable for Mr. Askew to rely on his supervisor's statements point blank here, because it's not like he only had the moment that he was presented with this situation to make his decision. He also had 9 days after he was presented with this decision to really think about it. And that's because he asked his supervisor, can I have 9 days to close out my cases? And his supervisor said yes. And during that time, he could have done many things. He could have gone to HR to figure out, do I have process? Is my supervisor lying? He could have gone to a lawyer to see, what do the Florida statutes say? I'm a government employee. Am I protected here? He could have rescinded his resignation and then accepted the adverse action, brought a lawsuit just like this one, and that's how a typical employment case goes. But Mr. Askew didn't do that. He jumped the gun. He prevented the department from taking measures to prevent this $1 million verdict, or nearly $1 million verdict against it. And we don't think that situation amounts to a misrepresentation claim that supports a constructive discharge.
So even if on day one, in those couple of hours, we don't think it meets an incredible standard because he had 10 days, at some point it does reach an incredible standard.
Exactly, Your Honor. Exactly, that's right. And I'd also note that we've noted on the back end he had 9 days. But under Hargray, he also had time on the front end. And that's because Hargray recognizes that when an employee is aware that he's being investigated for a particular terminable offense, we presume that the employee is able to consider and look into his options and think about, what would I do if I were presented with the choice between resignation and termination? And here Mr. Askew had about a full business week to consider his options because he knew he's being investigated by the Inspector General's office for about a full business week before this decision was presented to him. So we think he had plenty of time here, and it's just unreasonable for him to rely on his supervisor's
To what extent
statements.
does the record tell us that that termination would be a credible end, that he could think that the termination would be a credible end to this as opposed to some lesser sanction? It seemed like there was mixed evidence on that.
Well, I'd say two things to that, Your Honor. First, there's no dispute that this was a terminable offense. DCF's policy related to its confidential database is set out in the rules and statutes on page 1033 of the record. That's the OIG report. And those statutes and rules make clear that you can only access the database for reasons related to your specific job function. And if you violate the policy, that is itself a terminable offense. So there's no doubt that this was a terminable offense. But I take your question, Judge Osterhouse, to be saying, does he need to consider, or do we have to look to whether reasonable people would have been fired for this same exact offense, or was the department taking this particular policy for people who committed similar violations? And I don't think, I'd say two things. One, Mr. Askew has not provided enough evidence in the record to show that, DCF's real policy was not to enforce its policy to the fullest extent, and instead it had created a de facto policy where it was not terminating people for a violation of his magnitude, because he just hasn't had enough supervisors or instances in the record where he is showing that people are not being fired for similar violations, and that's his job to do.
So does that go in part to your analysis of whether there is discriminatory intent as it relates to comparators, that the comparators that were provided, either Badland didn't supervise, or there certainly wasn't any information about whether they too were disabled or not?
Yeah, that's certainly right, Your Honor. We don't think that there's enough evidence of discriminatory motive here. We think that speaks to it. But I will say, I do want to differentiate the arguments because we don't think we even need to get to discriminatory motive because this court can reverse because there was no adverse action, because there was no constructive discharge. And so we think that the point relates to both of the arguments. And so I do want to touch on Mr. Askew's duress argument, because there's two ways you can get to a constructive discharge. You can have a misrepresentation of material facts, and we don't think we have that here. And you can also say that you were just under duress because the circumstances were so onerous that no reasonable person would have had a meaningful choice in the scenario. And Mr. Askew has two arguments on this front. The first one is that he felt like he was under duress here because no reasonable person would have challenged their termination or accepted their termination and risked their retirement benefits. The problem is that Mr. Askew's retirement benefits were never in jeopardy in this situation because under Florida law, section 121.091 subsection 5, a state employee who is terminated does not lose their retirement benefits, barring exceptions that are just not relevant here. So Mr. Askew never had, his retirement benefits were never in jeopardy at all, nor did his supervisor intimate to him as much. Now, that's an argument he makes in the briefs. But if you look at the record, on his view of the facts, he asked his supervisor, what's going to happen to me if I'm terminated? What's going to happen to my retirement? And his supervisor said, I don't know. But she also said, I don't know how retirement is going to affect your retirement benefits. All she said was, I don't know how retirement affects your separation, and no reasonable jury can conclude that to mean that she was intimating, you better resign here or your retirement could be in jeopardy. And that leaves Mr. Askew with just one theory, and that's that he didn't have enough time here. He was under duress because he only had about an hour and a half to make his decision. But as I intimated earlier, he did have enough time here. In total, he had about 2 weeks because he had about a week, a full business week on the front end to consider his decision. He knew he was being investigated by the OIG. And he had about 9 days on the back end. And I do want to address Mr. Askew's Shingles argument. Now, he says, on the back end, I was out of the office for most of the time with Shingles, and the state certainly is sympathetic to Mr. Askew's condition. But 2 points. The first one is that he doesn't have any medical evidence in the record to show that he actually could not reasonably consider this important life decision because he was out with Shingles, or that the medication he was on prevented him from considering this decision. And more importantly, even on his view of the facts, he was only out of work for most of the time. So there were still a couple of days at least where he was at work. And Mr. Askew he did an important job. He worked in the Interstate Compact Department, so he was shuttling kids back and forth state lines. That's complicated work. That's important work. And we think that if he felt good enough to come into work, he certainly should have felt good enough to be able to consider this pretty important life decision. So for all those reasons, Your Honors, we think that this is a straightforward constructive discharge reversal, just like the court did in Hargray and just like the D.C. Circuit did in Perricksay. And unless Your Honors have any other questions on constructive discharge, I'm happy to move to discriminatory motive. Because even if there were a constructive discharge here, there was not enough evidence in the record to establish discriminatory motive. And
Counsel, just to note that you are in your rebuttal time, and you're welcome, of course, to proceed or save that for rebuttal.
I'll never miss a good opportunity to shut up. I'll save my rest for rebuttal. Thank you.
May it please the court, I am Ashley Richardson, and I'm here on behalf of the appellee, Mr. Askew, today. So I just want to address some of the arguments that counsel made, since it appears that the majority of the argument today is going to be on the issue of constructive discharge. It is quite the large and looming issue in this particular matter. So there are 3 ways that a plaintiff can prove constructive discharge. Only 2 of those are at issue in this case. We have misrepresentation and we have duress or coercion. I'm going to take those in the order that the court did earlier, so starting with misrepresentation. It's blatantly obvious on this record, and we have to keep in mind that this is actually a jury verdict. So the standard here is that there has to be no evidence, a complete lack of evidence from which a jury could find in favor of Mr. Askew on this one. So we have misrepresentation. We have to show that those facts were material. His supervisor came into his office and lied and said the the IG investigation is over. It was not. They did not find in your favor. That's false. You will be terminated by the end of the day. Also false. You have no recourse here. They want you gone. Nothing you do will change that. Make your decision. He has about an hour to make that decision. Now, counsel for the department has said repeatedly that he actually had several days prior to these lies to decide whether or not he was going to resign, to consult with an attorney, but that's not what the facts and evidence before the jury showed. He went in, had his investigation, gives his interview with the investigator general, and assumes, because he believes he has done nothing wrong, that he has exonerated himself. He goes back to work. He's told them what happened. It wasn't a personal use. Goes back to work as if nothing is going to change in his employment. Comes to work on a Tuesday, and his supervisor walks into the office and tells him he is about to be fired. He had no idea this was coming. There was no reason for him to seek legal counsel or consult with the Human Resources Office or determine if his retirement benefits were going to be at issue.
Counsel, so respond to the argument that, in general, state employees have constructive knowledge of the statutes and the rules with respect to disciplinary action, and this employee in particular perhaps even had more knowledge because of his supervisory experience, and so he should have known that immediate termination was not an option.
He testified during the trial that he was unaware that that was actually the state of the law. And I understand that there's the argument that it's constructive, but here the issue is he had 1 hour to suss out all of these details, to pull Florida statutes, to consult with human resources, and to determine what to do in order to preserve sort of his employability status, his financial future, essentially. He has about an hour to make this decision. There's no time for him to go and evaluate what his options may be. He's reasonably relying on the lies that his supervisor put out there that, like, there's nothing you can do. Like, you're getting fired today.
So what about the time that after that he requested to close up cases, and perhaps that would give him an opportunity to do that research?
And were this any other circumstance, I could say that there's probably a reasonable argument to be made there, but immediately after this horrible interaction with Badland where she tells him, like, you're fired, you're done here, he goes to his doctor, he gets put on medication for anxiety, and then within a few days develops a severe case of shingles that takes him out of work for pretty much the remainder of his time there. I have never had shingles. I have heard that it is horrifying and incredibly painful, and any argument that he was well enough at some point to do X, Y, or Z but couldn't reconsider his employment status is kind of far afield from what was presented to the jury.
Counselor, what should we make of the fact that, 3 days before he submitted the resignation letter, he had the IG interview, and at the beginning of the interview, the investigator laid out, this is an administrative proceeding, whatever happens here, it's subject to the agency policies. We're only doing fact-finding. Once we do our report, it's going to go to an assistant secretary. I mean, don't those comments put him on notice that there's a process, there's policies that are going to govern this? I mean, what do we make of that?
I would say that that's absolutely accurate, but at the same time, Mr. Askew has never been through an IG investigation that targeted him before. He walks into that interview, is told these things, there's a process, this is how it's going to work, and he gives his side of the story, again, as he testified at trial, assuming that he had sort of exonerated himself, like, this is what I did, it was all for the concern of this child, I didn't do anything wrong, and he leaves thinking this is all going to be fine. There's no indication, and then his supervisor walks in and proceeds to tell him that she has information. She's now the intermediary between the IG's office and him, and it did not go well. He is now terminated. There's no indication that there's no paperwork. There's nothing that she provides him, but there's also nothing from the IG's office. So he takes her as his supervisor at her word. You have received word from the IG's office that I am now fired, and this is the only option that I have. So to the extent that there is any kind of process, again, he's testified that he's not aware of any of those details. He's just relying solely on what his supervisor has told him is about to happen to him.
Your brief, switching to the other part of the argument, your brief talks about a mosaic of circumstantial evidence that indicates that there was discrimination, disability-based discrimination here. What are the highlights of that? Where can we see that most clearly?
I would say the biggest and most obvious is in Badland's interview itself. It's a 17-minute long interview, approximately the amount of time that I have to speak before you all today. And during that, she makes a dozen references to his physical ailments and his mental state. And now the department would have you believe, or wants you to interpret that as that she was very concerned for him. Oh, perhaps it was his, his mental state that made his, caused this lapse in judgment. That's not how the jury read it, and that's not how the text reads. She repeatedly cites his physical and mental issues as perhaps causing him.
So you wouldn't say that the text reads that it seems like she's coming to his defense?
I'd say that
he's got a 25-year career and this was a lapse, and he's got a lot going on, and so that should come into play.
I'd say that there is, you could interpret it that way, but based on her testimony at trial and the language itself, it is not unreasonable for the jury to have found that she was in fact targeting him based on his disability and any conditions.
Wasn't the context, though, and I'm trying to remember that testimony, something to the effect of, this is not like him to do something like this, is, so she was surprised and trying to figure out what could have caused this lapse in judgment.
I do believe that she mentioned something along those lines, but it's the sheer volume of references to his mental and physical decline that suggests that she had ulterior motives. There's also the issue of the parking pass and her, attempt to assist him in getting, this additional parking space so that he could get to and from work. He has serious mobility issues, so that he could get to and from work on, much easier, and she doesn't really do anything there. And he's also passed over for promotion, I believe 3 times, and none of the promotional issues are at issue or were before the jury, but they are additional evidence of the fact that he was passed over for promotion 3 times for candidates that Badland admits were not disabled. And one of those candidates he actually trained at some point.
Did Badland make those promotional decisions in those cases? She made one, and then she provided an explanation in that for that particular.
Correct, but it's still, when we look at it as a whole, all of these actions taken by her, that's the convincing mosaic, and the majority of that is based on her testimony before the IG's office. So that's, and then we also have the side issue of the comparators, those individuals, I believe there were 8 of them presented at trial, who were not disabled, who were not terminated or even threatened with termination by their supervisor. And yes, they were not supervised by Badland, but they were all investigated by the IG's office. So we believe that there is enough to show that they are comparators, and if not, that evidence assists in the circumstantial evidence, or the circumstantial convincing mosaic analysis. So if there's no more questions on that issue, I wanted to address several things on the duress argument. So we've talked about the several days before and the several days after. The biggest issue is Badland's belief, or good faith, good belief that what she was saying was true. So there's a small exception under the duress and coercion argument that the employee can show a constructive discharge where there's no evidence to support the supervisor's good belief that this was about to happen. And as I stated earlier, there was none. She was aware that 8 or so other employees were investigated by the IG's office for engaging in similar or substantially more personal use of this data network who were not terminated. She knew that. She knew that the IG's investigation was not complete. There's not a single shred of evidence that could have supported a belief that the IG's investigation was complete. It didn't happen for over a month. No one told her that he was going to be terminated by the end of the day. Again, not a single piece of evidence in the record before the jury that that was going to happen. She simply walks into his office and says, "You're fired." Her testimony would have you believe that a 25-year veteran of the department walked into her office on a Tuesday, had a pleasant conversation, and submitted his resignation. She testified at trial that she didn't really find that all that shocking. She was just like, he's resigned on a Tuesday. This man had no job lined up and no medical insurance. He has had severe, ongoing, and progressively more debilitating cancer since 1992. Surgeries, that's part of the reason he believes he was discriminated against, was because of that cancer and the manifestations that came along with it. To claim that he just walked in and voluntarily resigned is woefully undermined by this record, and we have to meet that high threshold to show that there's no evidence that a reasonable jury could sit down and review and say, I think that this guy was forced to quit, and that's our position. So if there are no additional questions, we'll end it right there.
Thank you, counsel.
Your Honors, I'd like to touch on a few points. First, I'd like to highlight the high hill that Mr. Askew needs to climb to establish a constructive discharge, and note that it is even higher than that of a hostile work environment claim. That's the 11th Circuit's decision in Bryant. So this is a very high standard that he needs to climb. These cases usually rest on egregious facts, like an employee being locked in a room until they submit their resignation, or being threatened with devastating public humiliation until they submit their resignation. That's just not the case that we have here. My friend on the other side said that Mr. Askew didn't know that this was a terminable offense, but as we've explained, Mr. Askew was an employee of the department for 25 years. He had read the handbook, and he's presumed to understand these rules. On the convincing mosaic theory, the convincing mosaic as well typically rests on egregious facts. An example would be an employer calling you deeply derogatory names related to a protected characteristic. And we don't think that the facts assembled here anywhere near approach that standard. We discussed the Ms. Badland's interview. I think no reasonable jury could read that interview to say that she was discriminating against Mr. Askew. She said in that interview, he's an outstanding employee. This is very uncharacteristic of him. I know he's been stressed because of his medical condition. Maybe that's why. We don't think anyone could read that to infer discrimination. On the, my friend on the other side said that the comparator, it doesn't matter that the comparators didn't have Ms. Badland as their supervisor because they were all investigated by the OIG, but that doesn't matter because what we're trying to figure out here is whether Ms. Badland acted with discriminatory intent, not what the OIG was doing. And so what the critical fact is whether they had Ms. Badland as the supervisor. That's how we compare and contrast to root out discriminatory motive. And finally, I just close by saying it's black letter law that the choice between resignation and termination is not a constructive discharge. The choice between two unpleasant alternatives does not arise to an adverse action by the employer. So for all these reasons and the reasons in our briefs, we'd ask this court to reverse the trial court's orders. Thank you.
Thank you, counsel. Thank you for the arguments presented today by both attorneys. The court is now adjourned.
All rise.
Should be my last one for a while. We said, we're not coming back next week. Not coming back next week. I have nothing else on the calendar with you guys. I know. I'm going to have to start bringing snacks to the guys downstairs if I keep showing up this often. I think my bag ate my keys.
Lower the podium so pictures in front of the bench.
We just wanted to say hello, see if you enjoyed your experience.
Thank y'all for coming over on a Friday. It was nice to have a full house today.
Yeah.
Hello.
Well, thank you guys for coming back in here.
Absolutely.
You want to tell students about yourselves and your connections to
You don't have to be all formal and all that.
No, yeah.
Yeah, this is always a treat to get to talk to visitors after oral argument. So my name is Stephanie Ray, and I've been
connection with FSU, which is part of your question, is that I graduated from FSU Law